Welcome to Hillsborough Township Planning Board meeting of July 13th, 2023. Please join me in a salute to the flag. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be advised this meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, otherwise known as the Sunshine Law. Notice of the 2023 annual meeting schedule and amended meeting dates have been provided to the officially designated newspapers, the Township Clerk, posted on the Township website, and available here at the Hillsborough Township Municipal Complex. In addition, application documents have been made available on the Township Civic Clerk website, and complete application files are available in the Planning and Zoning Department for inspection in accordance with the public meeting notice. For that, may I have a roll call of board members and also board and township professionals, please.
Mr. Wagner, Mr. Scobo, Mr. Delcor, and Committeeman Ciccarelli are absent. Mr. Peason?
Here.
Mr. Radowitz?
Present.
Ms. Smith?
Here.
Mayor Lapani?
Here.
Vice Chair Julian?
Here.
Chair Sirachi?
Here.
Mr. Coyce?
Here.
Mr. Bernstein?
Here.
Mr. Mayhew?
Here.
And the videographer and myself are here.
Okay, welcome everyone. Okay, we do not have consideration of meeting minutes, no resolutions, no board business, and no ordinances for consideration, so we will move to business from the floor for matters that are not on this evening's agenda. And just as a reminder, no commentary on warehouses because of the number of applications, including we have a couple this evening. We want to get those comments on the official records of those respective applications. So if anyone has anything, feel free to come to the mic, state your name and address for the record.
Maria Janusik, 720 East Freck Avenue, Manville, New Jersey. I'm also a Hillsborough Township property owner, Block 86, Lot 3, 2155 Camp Lane Road. There had been an application by Harvard Way. It was an application, and that had been denied by this board. Was there a change to that status, or is that denied, and that's it?
Well, I think it's in the courts, right, Mr. Bernstein?
Harvard Way. Harvard Way is in the courts.
Okay. Who from the township is representing the township?
Mr. Bernstein?
Attorney Bernstein?
Yes.
Okay.
Actually, myself and attorney for the carrier, for the insurance company.
I'm sorry, who?
The
I didn't hear what you said.
attorney for our insurance carrier,
For the
JIF.
insurance carrier, for the JIF.
Okay. We've been getting many transcripts of all the public hearings, and so I know that Mr. Michael Lombardozzi is the reporter. Who does the transcribing?
Mr. Lombardozzi.
So Mr. Lombardozzi does the reporting and then transcribes his own work?
Yes.
Okay, so this is a quasi-judicial body. Does Mr. Lombardozzi have to have is he required to have an administrative office of the court's AOC number?
No.
As a transcriber?
No, this is not an AOC issue. Doesn't fall within the jurisdiction of the administrative office of the courts,
Okay, so
for those of you
those-
wondering what AOC is.
Okay, so even though it's quasi-judicial, that's not a
It's
requirement?
considered a quasi-judicial board, Ms. Janusik. It is not under the auspices of the New Jersey court system.
Okay, when we get these transcripts, Mr. Lombardozzi's signature isn't on there.
Doesn't have to be.
It doesn't have to be, even though it is considered, I guess, a government document, and shouldn't officials have to sign those documents so that we know that's from him?
It does not have to be signed for purposes of the board.
For purposes of the board,
Yep.
but when it's given as a public record, it doesn't have to be signed?
No. It's an official document, whether it's signed or not. It is the official transcript of the board.
Okay. Recently, the Hillsborough Township Committee approved an ordinance to forbid warehouses as permitted uses in the I-2, I-3, the I-1, I-2, I-3 light industrial zone, the LI light industrial zone, and the GI, I guess that's general industrial zone, so that these warehouses are no longer a permitted use. Has notice been sent to the property, excuse me, the owners of the warehouses in those zones, because they only have 1 year to apply for a certificate of nonconformity, and after that, they have to go before the, they have to apply for a variance. So has notice been sent to all of these owners?
Squires?
Notice is not required to send to them. So the township, we put out frequently asked questions for, stakeholders, essentially, communicating their, rights to be able to, within that first year, apply for a certificate of nonconformity to the administrative officer, which is the zoning official for the township. And then after that year, they would have to go to the Board of Adjustment in order to get a certificate of nonconformity. I'm not aware of any notice requirement, and I'll defer to legal counsel in terms of us having to send them a notice. In terms of the ordinance being adopted, it had to be noticed, public notice, and that met the requirements.
So property owner, so who received notice? Because I think I had gotten a notice from the township that ordinance was going to be heard. So the the owners of the warehouses didn't have to get notice of that ordinance by mail, by certified mail?
So in the beginning, they would receive any of the properties within the zone and properties within 200 feet would have to receive personal notice. And then there would also, yep.
That's for the adoption of the ordinance. The issue
Right.
is, are we required to provide notice once the ordinance is adopted to the affected parties?
So to that question, the answer is no. But to my question, was notice sent about that ordinance to all owners? Because I know that, I think there was one owner who came and spoke at the public hearing. I don't know if that was Mr. Larkin or someone representing him, but I didn't see any other warehouse
That's an issue for the
owners.
township committee.
And
They-
so,
Ms. Janasek, everyone that was supposed to get notice received notice per the requirements of the meeting. There were several business owners there, all of them represented by the same legal counsel, as I recall, and they spoke on behalf of several of them, so they are aware of the ordinance and the passing of it, yes.
so you're saying that all of the property owners received notice about that ordinance?
That's an issue, actually, this is an issue before the township committee, Ms. Janasek, not within the jurisdiction of this board.
Right, so we have
So if
something
you have
else.
those questions, you can ask the township committee.
It is in regard to zoning and in regard.
It has nothing,
what is permitted in the zoning.
the issue of notice and procedure relation to the adoption of a township ordinance falls within the purview of the township committee. And therefore, if you have these questions, I know you know where the township committee and when they have their meetings are, they're the people to ask the questions. It's not a board issue.
So then, any any warehouse owner who does not apply within 1 year for a certificate of nonconformity will have to go before the, Board of Adjustment?
Not an issue before this board, not a question I would recommend being answered. Move on.
Thank you.
Thank you. Okay, seeing no other comments, we will move on to this evening's applications. First one is 303 Amwell Road, file number 21-PB-17-MSPV, with the time of decision of September 28th of this year. My understanding is the applicant's requesting to be adjourned to a day to be determined by the boards. I don't know if there's counsel here. Please come forward.
Mr. Chairman, Matt Flynn from Sabo Shaw.
You could sit.
You get the sip.
Just briefly for the adjournment, but.
All right.
Yeah, thank you.
And I don't know, should I invite up, I know there's an objector listed, Craig Berlin?
And there he is.
There he is.
Perfect timing.
Good stretch, I appreciate it.
Yeah, it's on.
Good, how are
Done.
you?
Mr. Flynn, place your name and association on the record, please.
Thank you, Mr. Bernstein. Matt Flynn from the law firm of Savo Shock on behalf of the applicant.
Mr. Berlin, for the purpose of the record.
Craig Berlin, Alls House Street.
Mr. Berlin is the objector in this application. Mr. Flynn?
The applicant is seeking to carry this to a date, I believe, in October, which I believe is the next available date. Some more time to get plans in order, and as the board's aware, the principles of an application that's on for tonight is moving forward, and they have prioritized that application in front of the board and would like to push the 303 Amwell off to October.
Well, correct me if I'm wrong, Mr. Coyce, your client has an application on for October the 5th for the application that's actually on for tonight, and that there is another application on for October the 12th, which your office is representing, that is not tonight's client. So the next available meeting would be November the 2nd.
That is the date that we were holding when we last spoke to Mr. Ogrodnik.
I'd like to just question it, I don't know if this is on.
Hit the button.
Is it green?
Now it's green.
Now it's green.
Yeah.
I'd just like to question at what point, say October 2nd, they come in and they're still not ready. We've been waiting for plans for quite a while. I'm wondering at what point the plan is ready to take a vote to ask the applicant to please file again. I haven't seen any movement. The last time someone was here, last time we were all here, I believe it was back in March. And in March, we accomplished nothing. And I believe the meeting before that, we accomplished nothing. And we were looking at the definition of warehouse. I think they've had enough time to get this thing up and before the board. I'd like to see this off of the board's plate, but most of all, I'd like to see it off of my plate. It's becoming an inconvenience, and I don't know that it's being served correctly. I think that the application has had ample time to get their paperwork in, or at least make some gesture towards what they're getting at. And I'd like to know if there is a date where this all runs out of time.
The answer to run out of time is as long as the applicant still has a pending application, has granted a time of decision which has been extended to beyond the time in which the applicant is being heard, they still have a valid application. And as far as I'm aware, Mr. Flynn can answer, his client is not intending to withdraw the application at this time.
No, they'd be looking to carry to the next available date, which it sounds like the first meeting in November.
So, Mr. Bernstein, just for everyone's edification, how long can an applicant continue to seek adjournments?
As long as it still has a viable application, Mr. Chairman.
And what's the definition of viable application?
One that's currently before this board in some manner and has been deemed complete by the planning department for purposes of bringing it before this board or the zoning board.
And what if,
It is
like,
still a valid application.
okay, what if the state starts to, add some additional requirements?
This application is grandfathered
Okay.
unless the state retroactively, which would be a first, retroactively applies regulations to a period of time outside the time in which the application was deemed complete. Understand, the issue nowadays is time of application versus time of decision. As long as it makes it within the time of application, as planning department is well aware, then they still can have a viable application until such time as either they withdraw it or there is an intervening situation brought to the attention of the board professionals that would render a decision to be made to this board relative to the standing and completeness of the application.
Thank you.
Yeah, I mean, my client just told me that he'd be willing to entertain a date in August or September. I know when my colleague spoke to Mr. Coyce that Scheduling meetings in August can be problematic with quorum, so.
No, scheduling in August is non-existent.
Okay, there you go.
For 23,
that's quite-
let me be very, for everybody who is here who's asking, for 23 years, this office has been the board attorney, and for 23 years, this board has never met in August, no matter how many applicants have come before the board over those years asking for August. There are no meetings in August. There is no meeting in September, because the 2 meetings in September that the board has are already booked by another warehouse applicant. So, and actually, there are available dates in October if your client is willing to substitute another application he currently has for this one. If he's not, it's November the 2nd.
So that's what we would request then, November the 2nd.
And with regards to time of decision, and let's get a date out there that's realistic, because I don't think we're going to get this done in one night. So I don't want to hear November 30th,
Right, I mean, I guess at that point, then it would be end of the year.
right? Because I don't think we can carry into the new year.
Right.
We could if we have a schedule adopted, which is a conversation I've had with Mr. Coyce in the interim, and will probably continue to have, is whether the board establishes this calendar for 2024. Oh, my God. In 2024, before 2024, so.
It's always a fun first meeting of the year is to do, start scheduling out half the year,
Yeah,
so.
all right. So this would,
Okay.
Mr. Chairman, would be a motion, and Mr. Flynn would have to sign his life away. It's a motion to continue I guess-
21 PB 17.
21 PB 17-MSPV, 303 Amwell Road, to November the 2nd, 2023, at 7 PM or soon thereafter, as the matter may be heard, without further notice, and an extension on the time of decision to December 31st, 2023.
Okay, may I have a motion?
I make that motion.
Second.
Okay. Roll call, please.
Mr. Peason?
First, I'd like to just remind the applicant and council of our 10-day, any new information, at least 10 days before. Don't spring it on us, right before the November meeting. So with that, yes.
Mr. Radowitz?
Yes.
Ms. Smith?
Yes.
Mayor Lapani?
Yes.
Vice Chair Julian?
Yes.
Chair Sarachi?
Yes.
Thank you.
Okay. We have oh, there we are. Okay. Next, we have Hillsborough 206 Holdings LLC, file number 18-BB-07-MSPV, 2019 amended site plan. And I know this is our somewhat regularly scheduled update, so.
Mr. Chairman, are we allowed to hear an application that's not warehousing?
I might need to have some references, because
Counsel, place your appearance on the record, please.
Thank you, Mr. Bernstein. For the record, Richard Hoff, a law firm of Biscayne Hoff. I'm here on behalf of the applicant, Hillsborough 206 Holdings, LLC. As the chairman indicated, this is our annual pilgrimage to the planning board to provide an update relative to the ongoing construction at the project, which now has a name, so it's the Hillmont. As the board knows, this was approved back in 2020. The resolution contained a condition that required the commencement of construction on the retail portion of the project prior to 50% of the COs for the residential. I imagine that that condition arose from a concern, I think, that this would be sort of a bait and switch, that we would do the residential, not do the commercial, and it was always the intent that this would be a mixed-use project. So we accepted the condition. We moved forward in that regard. We came before the board last year because at that time we were, as Mr. and with me here tonight, Mr. Jack Teicher, he's a principal. He was here last year to provide the board the update, and we'll get to Mr. Teicher in a minute. But just by way of summary, we came back last May to explain to the board that we weren't having the best of luck just soliciting tenants that wanted to build to suit. So we were concerned about having a situation where we would have to stop construction of the residential, which, as the board knows, contains an affordable housing component, So the board was courteous enough to really push the deadline out, and the condition was modified to provide that we would be entitled to construct 13 of the 14 buildings, but the last CO on that building would have to wait for another update relative to the retail. So again, we were appreciative of the board's indulgence in that regard. Following that meeting, the applicant just came to the conclusion twofold. One, we didn't want to risk having a situation where at the end, we're hamstrung and we've got people potentially lease not being able to move into a building. And two, we weren't doing any better trying to find someone on the build to suit. So the applicant made the determination recently to go ahead and proceed with construction on the first 2 retail buildings. The site work has started on the pads, and the permits are in to Mr. Coyce's office for review. So we believe we're here tonight to really ask that we can stop coming back. The building permits will be issued, and we intend to proceed. Mr. Teicher indicated to me approximately 30 days, where, assuming we get the permits, we would start doing foundation work on the first building. The idea would be to do the first, move to the second. We'll be candid. The third building is anticipated as a drive-through. That's not one that we would likely just do on spec. That's something that we would look for a specific user for, because not all drive-throughs are created equal. So we would hope, once we get the first 2 buildings up, the residential occupied, there's going to be sufficient interest of a user for that drive-through that we would then likely proceed on a build-to-suit basis. But even if that third building is not immediate, we still believe that we've complied with the provision of the resolution, which required commencement of construction on the retail portion. And because of that, we are here today to really ask the board, as I indicated, to accept that that condition is satisfied and we can just proceed and build it out in due course. So.
Mr. Coyce?
Thank you. Just for some clarification, Building A received a zoning permit about a year ago. Recently, I believe, I have it in my report, the date that it was granted a building permit to start, to commence construction. That was on May 15th, 2023. Within the last week or so, we received the zoning permit for Building B. It was recently denied. And so I assume we're going to be receiving an application, a modified application for that. At this time, we have received no permits for Building C. And as my report indicated, to date, 6 of the 14 residential buildings have received TCOs at this time. No COs have been issued for any of the buildings except for the clubhouse. And I also wanted to bring to the board's attention of the developers agreement, that the agreement for the non-residential component was for 3 buildings with a total area of 12,500 square feet of retail space ratables required to be constructed.
Okay.
We don't take any issue with any of those details. That accurately reflects where we stand, and we remain committed to building out the retail, and believe we've started.
Mr. Bernstein?
I think the issue, Mr. Chairman, and I think it's sort of highlighted by Mr. Coyce's report, is where does the board want to go from here? I know there has been concern over the years with the board as to, and I put this in quotes because it's a very liberal use of the word spec, that Mr. Hoff's clients have come in dutifully, as they agreed, to give you all an update, and pretty much the story has not particularly changed from year to year, pre-COVID and post-COVID. They are having problems filling with tenants the proposed commercial space. The board's concern, I believe, has been the issue of whether or not building such buildings, whether it's building A, B, and/or C, is going to get the desired result, or we're going to simply have empty 12,000 square feet of empty commercial space or some subset, because I think, as Mr. Hoff has indicated, his client is probably not inclined to build the drive-through without a real tenant. So probably about 8,000 square feet of the 12,000 or so, plus
Less
or
than
minus. Yeah.
A little less than 9.
All right, why don't we swear Jack in first with Michael?
You swear any testimony you give tonight is going to be the truth, the whole truth, and nothing but the truth?
I do.
For the record, can you state and spell your name?
Jack Teicher, Tycher,
Thank you.
And with whom are you employed by, Mr. Tack?
Canoe Brook Development,
Okay, and they are the developers for this site?
one of the two.
Okay. So the two buildings alone are about 9,000 square feet, as you heard, but for purpose of the record, at least sworn to. So we're back to that question. What do you all want to do? Do you want to, as it relates to the the building is going on, correct me if I'm wrong, they have not been rented out yet?
We are in negotiation with one lease for approximately 2,000 feet.
I'm
Of the-
talking about the resident?
Of the residential, yes.
Excuse me.
We've leased approximately 65 apartments so far, of the 175.
All right.
Of all the buildings so the 13 buildings, they're all complete and ready to be occupied? Or are they still in various degrees of build?
We think we'll be at least able to get TCOs by September, October for all buildings,
With the exception of the 14th building? Or including?
including the 14th
inclusive?
building pending, obviously, the issuance. But we think construction will be substantially complete in the third quarter.
And how many affordable units, refresh my memory, were on your
I want to say it's 40,
Project.
42, I believe.
42? And
175 total, 42 are
42
affordable, 24%.
and how many buildings are occupied right now?
Occupied, I don't know.
Ballpark.
Leased,
Six. Leased.
yeah, actually occupied, yeah. less than
Residential
10.
buildings, Mayor?
Yeah.
Yes.
I believe 6 have been TCO.
Six are leased, occupied, there's maybe 10 units occupied so far, but every day someone else moves in.
And the affordable units that are available, they are being fulfilled as equally as the other units?
It's a slower process, but yes, the administrator is going through the process of finding applications.
If I may, Mayor, there's a phasing schedule that they're required to follow, and the TCOs accurately reflect what they're supposed to be doing. So right now, the information we have, they are in compliance with the phasing schedule.
Okay. Well, I'll just put in my 2 cents, Chairman. I mean, I understand the struggles of retail post-COVID. I mean, we have buildings that were built that are empty, and I understand why. But our concern still remains that it will never be built, right? And I don't know how we.
No, I think the issue now, Mr. Chairman, is it'll be built, but there'll be nobody in there.
That's what I'm saying. They'll build it with nobody in them except for the pad for the quote-unquote drive-through, which would think to me be the one that would be the most desirable, but I guess not so much. I don't know how we can control that anymore and still be responsible enough to get these affordable units built. That's where my concern is.
Mr. Mayor, to that comment, I mean, obviously, we'll say it even though it goes without saying, we're obviously motivated
I understand that.
to occupy that space. We have no interest in an empty building either.
But, so your plan is to build 2 of the 3
Correct.
on quote-unquote
Correct.
spec with some tenants that you're negotiating with now, and we want to reserve the right to build the 3rd one when you have a tenant.
That's our request.
And they get the 14th building, I'll call it,
Correct.
released.
Correct.
I don't know if anybody else, I appreciate their diligence, and I would, if they're going to build the 2, I would say that would be satisfactory, in my opinion.
And hold off on the 3rd for the time being?
I would give them the opportunity to pursue it, because having it built and empty, that doesn't necessarily make it a viable project either way.
I mean, I know,
We're certainly not
We'd like the right to
stopping
build
leasing
it.
Yeah, I
activity.
understand. I mean,
Right.
the two buildings give us an opportunity to see the project fulfilled to that certain point that at the last project, that drive-through. I can understand why you'd want to wait for a hard tenant on that one.
Yeah, I mean, unless something drastically changes.
Mike?
Unless something drastically changes with the, any of the tenants or, as time goes on. I mean, a lot of the retail 2 years ago is different now. A lot of different medical buildings
Yeah.
pop up and.
That's really most of the interest right now,
Yeah.
frankly, is health and wellness and medical.
So, I mean, the whole dynamic is changing. So I would say, like, unless something drastically changes, I don't see why anything else would
I mean,
be.
you have a pretty captured group of people there at the end of a road. You would think that and this is just me, a store that would cater to the people in your development might be a viable use, right? A small convenience store or
There's one convenience
Yeah.
store we're speaking to very loosely. There's many medical and health
Right.
services. The one we're negotiating with right now is a trainer. So those are definitely the viable uses right now.
The only concern I have, because I know we have, I'll say, other applicants that owe us something, and I just want to make sure that this would not give them perhaps a way out of that obligation.
Any applicant who, and quote, owes us anything, it relates to the building of projects that have not yet occurred or have been approved but have not started. The one commonality to Mr. Hoff and his client is that they have built this project as they've been required to do. The units are included within it, they're mixed, it's an inclusionary development in the true sense of the word, and they have moved this process along. So whatever is basically the board's desire to make sure that we don't end up looking at empty, or the township committee having people coming to visit, why is there 2 empty retail buildings in my development, as if I'm assuming that when they rent them, they tell them that. But people tend to not remember those things at appropriate times, so.
And they've come for 2 years now with our update that we've asked them for. So they've lived up to the agreement that we set at the time of approval, which we could impose on anybody else, the same agreement.
Right. But also, as I look at, they knew what they were offering, and, and that's where I have a little bit of a concern was obviously these type of projects provide a little bit more leverage, I'm going to say, for the applicant to get
Well,
more out of the property than otherwise.
Mr. Chairman, if I may,
Sure.
This was the original application that we resolved. And as strange as it's about to sound, the declaratory judgment action entered us to affordable housing pursuant to Judge LaVecchia's decision. It was 2005. No, pardon me, 2015. So Mr. Hoff and his client were the first ones to resolve with us. They have pretty much continued to do what they need to do within the context of it. The leverage they have is actually little to none in terms of what we've been doing. We've probably had more leverage. We wanted an inclusionary development. We got it. We wanted some commercial aspects, and unfortunately, the economy has not always cooperated with the situation in terms of that part of the industry. So, similar to another project in downtown, which has similar aspects to it, it's the same situation. Applicant has done everything that we have asked him to do.
Yeah, I just would not like to see a repeat of what we have in downtown. That seems to just kind of be one of those nagging issues that just, will not resolve itself. And I'm just wondering if we can get maybe creative here?
Well,
'Cause
that's the
we
question
have-
is, if you want to get creative, is the applicant interested in being creative, and what's the creativity?
Are you asking that we don't build the building on spec? I'm not sure what you're asking.
Perhaps in lieu, change the third building into something else, perhaps additional, Because we have in 2 years. Round 4 starts to come about.
I don't know.
We would,
Go ahead.
Okay.
I don't know the building, I mean, if that's something the board's interested in, I don't think building 3 in and of itself would be enough space to do that. If you'd want to consider that, I think we'd have to do that right now and maybe build building A, but not build building B. We'd have to make some quick changes. I think
Hey, how close are you to signing leases for the A and B? I mean,
A, we're we're in a lease negotiation. It's not imminent. I'm not signing it tomorrow, but we think the next few weeks we could sign one lease for approximately 2,000 feet.
out of the 9,000.
We're certainly happy to discuss further apartments, but I don't think building C in and of itself would be enough space for the parking and a viable building.
How many square feet are we talking about?
For building C is 3,000 feet, but the parking for apartments is obviously
Yeah.
significant.
What kind of, and I don't, of course, remind this was 2 years ago plus, do we have, what kind of green space do you offer? You have a clubhouse, but is there a playground or a park for the tenants there or any kind of?
We don't have a playground, but we have significant amenities. There's significant green space in between all the buildings, so everyone has effectively a backyard on the first floor of all the apartments. We've got a pretty large, oversized stormwater basin. There's a dog run. There's not a tremendous amount of, I mean, there's plenty of green space, but there's not like one field that's just kind of sitting there ready. We certainly could not proceed with any of the buildings if you want to have that conversation.
Because I'm just saying, I mean, they only have 2,000 proposed out of 12,000. I mean, I say empty. Even, with only one tenant proposed.
Board's call.
So in lieu of a retail, would it be something that you would look at as maybe to develop, maybe and this is just as an idea, thinking about like a small pocket park for that area?
I don't know that our lender would, I don't know that, I mean, for that 3,000 feet you're talking about, I think I'd want to preserve the right to build in the future, but if you're asking for a temporary pocket park and when there's a build-to-suit tenant, we would take it offline maybe. I mean, we do have pro forma income for that space. I don't think it'll be unrented forever.
So you're proposing that you would maybe develop it as a pocket park, and then at some point, if you had a tenant to develop, you would then develop it at that point?
If you're asking if we don't want to, yes, I'd rather, particularly if we build the first 2 retail buildings, I'd rather not leave one space just dirt, so we'd probably lawn it and put in some temporary landscaping, and so.
Make it look finished,
Make it look finished, yeah.
not putting parking or any of that kind of stuff? Just the parking?
We're not looking to put in extra parking now, just for the sake of it. With regards to what we could do otherwise, I could come back to you with some ideas. We'd have to do it quickly, but I could look to see what we could fit.
So is there, and just, I don't have recollection, is there any residential above the,
No.
No.
and then the commercial buildings? Okay.
And we weren't, when we negotiated, we weren't looking for that. This is not really an area that lends itself to vertical.
Yeah, and I just wanted to make sure that there wasn't
2 over,
already.
3 over 1, it's not really a.
Yeah, I just wanted to make sure there wasn't,
No.
already a residential
These are
component.
standalone buildings.
Yeah. I mean, it's just kind of my concern is there's only 2,000 square feet out of, okay, so now 9,000 is going to be built. We got more than 2/3 right now sitting empty.
So he's looking, he'll build the 2 and just leave the other one until we get to tenant.
Please.
I'm sorry, I'm talking to myself. So he's, I'm talking out loud, I'm doing Italian things. So he's proposing to build the 2 of the 3 lots, quote unquote, as required, and is asking basically to reserve the right to continue on and then at some point do the last lot if you should find a tenant, in a nutshell, to put a bow
Yes.
around it, right?
Correct.
Right, so I would say that would be agreeable if he would at least make sure that 3rd lot is greened, usable as a, grass, doesn't look dirt and unfinished. And then at some point, if you should send, then you could then come back and then do to the planning department or Mr. Coyce to submit the plans for that last building.
That's fine. I'd request you don't put a condition on the timing for that
No,
grass.
not putting a timing.
Okay,
I'm just saying you would-
I'd rather finish construction before you do that, but yes, that's fine.
How about as part of the condition for Building 4, we at least get it finished by then, or Building 14?
I'm sorry?
At least as a condition for Building.
We'll never
We're
make
going to
it.
be close, we'll be way ahead of that.
Yeah.
Building 14 will deliver, be ready for occupancy, notwithstanding TCOs this fall. I mean, we'll just be starting retail construction.
So you're saying that you want to have.
Some type of a, I think we should have a, well, I mean, okay, I understand it may not, if they're moving ahead that quickly, but maybe at least do put a timeline at either the green space or to build.
Sure.
So that doesn't, so that we at least have some assurances to get, it looks finished.
Upon completion of construction of the first 2 retail buildings? Yeah. We will pursue it diligently. We're not looking to
Okay.
drag out the process
Yeah,
once
that's-
No,
we
that's
start.
That's fair.
Okay.
This way, if the 2 are done and you don't have a third tenant, you at least finish it and it looks finished.
Yeah, we don't.
Correct.
Okay.
That probably is our intention anyway.
Counselor, we wrap that one up in a bow there. I'll make a proposal, how's this, that we would allow the tenant, the applicant to finish Building 14, continue with the building of the 2 retail spaces with the understanding if he does not have a tenant for the third space, he would finish that off as a green space with the right to add the lot if he should sell it in the future.
And to provide an update to the board by the end of November in writing, so that Mr. Hoff doesn't have to.
In writing is great.
To give us an idea, and if the board, depending on what they see, would like to Mr. Hoff and his client to come back, I'm sure they will.
Mr. Bernstein has my number.
Okay. So with the mayor's motion, or proposal, may I have a motion?
I'll make a motion.
I'll second.
Okay. First, I'm just going to ask any comments from the board.
Yeah, I just have one, and this is just a procedural matter. Mr. Bernstein, I was not a member of the board back when this application was approved. Do I have standing to vote on this amendment?
I would probably abstain, Mr. Radowitz.
Fair enough.
Probably, I think Ms. Smith as well, because I don't believe she was part of all of this either.
Only the one last year, but no, the original approval.
I think there's sufficient members of the board who come with a history of,
4 is enough?
this has to be open to the public, Mr. Chairman.
We have
Okay.
a first and a second, so.
Once we get a second, then it's open to the public.
Okay. May I have a motion to open to public?
So moved.
Second.
All in favor?
Aye.
Aye.
Okay. Anyone from the public would like to comment on what's being proposed? Please come to the mic. Again, state your name and address for the record, please.
Maria Janusik, 720 East Quebec Avenue, Manville, New Jersey. Is it my understanding that you're allowing changes in the original application that was approved by the board?
They're not changes per se as far as the design, it's just more timing.
Correct.
Phasing, good word.
Okay, but you're saying that upon completion of the first 2 retail buildings, if there's no tenant for the third one, it can be a green space. But the original application was for 3 buildings, right?
Right, and they still have that, it's just that we want it to look complete, not like it's, an empty lot.
So does this have to be put in writing or a new plan presented so that it's on the records of the township, what transpired here?
It'll be adopted by resolution at a subsequent meeting.
So the applicant doesn't have to provide anything new in case they don't have that third building and it becomes a green space?
The motion
No.
was to give the board an update by the end of November as to the status of the commercial buildings and the status of the green space.
Okay. So originally, this applicant was an intervener for the Hillsborough Township's affordable housing requirement?
Actually, we stopped them from becoming an intervener. We talked them out of it, and they are in the township's plan, but they were not a direct intervener. They originally filed and then withdrew.
Okay, because there was mention about the declaratory judgment.
I was just mentioning it for the purposes of the time frame we're talking about. We were in these conversations with Mr. Hoff and other counsel as far back as 2006 on this application, so It's
What year?
been,
I'm sorry, what year?
what?
2016.
16, pardon me. I know, I don't like it. 10, I keep trying to make myself younger, I think. Yes, ma'am? What was the question?
You were saying something about what you mentioned 2006, which threw me
So
off.
2016.
In 2016, I'm sorry, can you continue?
2016, we came to an agreement with this applicant. It was 16 or 17. They were really the first of the many interveners or quasi-interveners in our affordable housing application.
And I think to his point was the fact the economy was different back in 2016.
16 than it is
The
now.
point was that the economy was much different in 2015-16 as far as looking at retail space as to post-COVID, is really what the point of his comment was.
As well as the fact they've been cooperating with the townships throughout this process and moved the project along to where we are today.
So this application came in as 206 Holdings?
Yes.
And now it's called Hillmont?
The development is called the Hillmont. The applicant is still Hillsborough 206 Holdings LLC.
Okay, so the application was called Hillmont? The development was
No,
called Hillmont?
the development is going to be called the Hillmont.
Okay.
The applicant is Hillsborough 206 Holdings LLC.
Okay. Mr. Boyce mentioned something about that they're in compliance with the phasing schedule. What is the phasing schedule?
As set forth in every development agreement we have, which I believe you have copies of, under the Uniform Housing Affordability Control, they have to build one affordable housing unit starting at 25% and phased up to at 75%. They have to have all affordable housing built, not necessarily occupied, but built. And they are doing that throughout the project as we speak.
So is the residential component, is that all complete? Not
All-
just the affordable housing? but
The affordable housing is intermingled with the market. There is not a standalone affordable housing building or buildings. They are part of each building that they are building.
But what I'm asking is, affordable housing and market, is that the residential component, is that complete?
No.
No.
One building is still left to be complete.
So how many units are?
Just went through that.
What?
We just went through all that.
There's 13 buildings.
14.
14th is the last one.
Yes.
I didn't hear that, I'm sorry, because there's been a lot of talk, there was a lot of discussion. Chairman Sirachi kind of had a conversation here, and I didn't hear what was being said, so that's why I'm asking questions.
There are 14 total buildings in the project. Currently, 6 of those buildings have temporary certificates of occupancy. The remaining 8 have been constructed, but they are not yet ready for occupancy. We would anticipate all buildings to be ready for occupancy by the end of the year.
And do you know how many affordable housing?
42.
Available now?
Available now?
I don't know exactly. I don't know exactly. It's proportionate, roughly. It's
Yeah,
prorated.
we have a phasing plan that details how many affordable units are in each building, and there are affordable units within each and every of the 14 buildings.
But you don't know how many?
I don't know, yes, sitting here right now, we don't know how many of the leases that have been signed are actually for affordable households versus market rate units.
Would that information be available if I were to submit a OPA request?
I don't believe that certainly the developer's agreement, which identifies the units, but I don't know that we would be giving out whether those units are occupied or not.
I'm not asking if they're
All right.
occupied, I'm just saying.
Ms. Janusik, for the
how many
purposes
affordable-
of why they're here, we're not talking about where they are with the building affordable housing units.
When the 14th building is complete, Mrs. Janusik, all the affordable housing units will be done.
Okay, but right now, there are some affordable housing units that are complete.
There are some built- there are some-
Did they receive the TCOs?
There are, as Mr. Hoff indicated, 6 buildings, not 6 units, 6 buildings have received TCO, of which there are affordable housing units within them. There are 8 buildings still remaining to receive TCOs. They all have affordable housing units in them.
Okay, so the ones that have the TCOs, are those affordable housing units available for tenants who require?
Yes.
Yes, they're available.
Okay, And so the question is, how many of them are there?
Okay, I'm going to stop the line.
That
because
actually
it's-
is not
it's
an issue
really-
before this board.
Right, it's, yeah, you
It's all
should.
part of this development.
It's not part
But
of
it's
why we're
not
here.
relevant to tonight's, why they're here tonight. We're not talking about
Mrs. Janicek,
where they
I-
are with their affordable, you know, with the.
I
with
know you
their
love
building.
this so-called global issue, that anytime any issue appears before somebody, it therefore makes it inclusive on that board or body to answer all questions. The applicant has met the requirements. They are building affordable units. As to how many may or may not be occupied, that is an item, if we even have the information, that comes through the township and not this board. And just because it's part of the zoning doesn't mean it's part of this discussion.
But this application was part of Hillsborough's affordable
Okay,
housing.
Ms. Janusik, you're again going off on a tangent. That's not, Ms. Janusik,
That was mentioned here.
it's not relevant for why they are here. Do you have something very specific with what the resolution?
So specifically then, why are they here?
They were here to give their annual update with regards to their development or building of the 3 commercial buildings.
That's it.
And that was it. They gave us our update. We actually provided some guidance, I'm going to say, that we're going to memorialize in the resolution that is right now standing for a vote. So if you have a question with that,
Yeah.
the resolution itself,
I think Mr. Coyce mentioned something that the permit for building 2 was denied. Is there, what was the reason?
No, the permit for, the original zoning request for Building B has been sent back for additional information.
that would be a question of the building or engineering department.
Okay, well, because Mr. Coyce mentioned it was denied. So that's what I
Right.
wanted to find out. So that's because what, they require more information?
You'd have to speak to building or engineering that denied it.
Mr. Coyce mentioned it, so.
Well, he just mentioned a fact,
He
so,
doesn't know
but
the
he doesn't
reason.
have the, he may not necessarily have the background information or the, the reasoning why it was. So it's not, and again, it's not relevant for why the applicant is here tonight.
So that building 2 is the commercial component?
Yes. Thank you. Okay, see no one else, so we will move on with roll call, please.
Mr. Peason.
Yes.
Mr. Radowitz.
Abstain?
Ms. Smith.
Abstain?
Mayor Lapani.
Yes.
Vice Chair Julian.
Yes.
Chair Sirachi.
Yes. Okay,
Thank you.
thank you.
Thank you, Mr. Hoff.
Thank you. Thank you very much.
Mike, you're doing okay, right? All right, so we will now move on, what I will call the main event tonight, Homestead 279 LLC, file number 22-PB-05/MSPV, time of decision, July 31st of this year. The application was adjourned from the June 8th, 2023 meeting without further notice, and I see everyone has taken their seats, so that's good.
Good evening, members of the board. Matt Flynn from Savo Schalk Law Firm on behalf of the applicant, Homestead 279 LLC. I'm assuming you want the objector to put his appearance on the record?
Good evening. Joseph Torriello on behalf of resident objector Sandro Iannella.
Mr. Flynn, I would ask that you give a brief update to the board as to the revised application that your client is bringing tonight, and then I believe we're going to have some discussions regarding some issues involving the application and related items, but for purposes of just indicating what this application is.
Sure. Thanks, Mr. Bernstein. We were last before the board on March 9th. The board will recall this is an application for preliminary and final site plan approval for the construction of a now revised 113,580 square foot warehouse facility. The property is designated as Block 200.02, Lot 12, and otherwise known as 279 Homestead Road. The proposed use is considered permitted as part of this application, and since we were last before the board and responding to concerns of the board and the objector, we've made a few changes, and I'll just briefly go over them. Our engineer will get into them more substantively. Notably, we were contemplating at the last meeting the elimination of the subdivision. The applicant will be moving forward with that design. So per section 18874 of your ordinance, it does allow for 2 principal buildings on 1 non-residential lot. That's what's being considered here. The applicant has provided some draft documents for the board's review to detail the proposed sort of condominium arrangement that the applicant will have with the existing owner. We also did provide an updated and notarized owner's consent form indicating that the applicant does have standing to proceed tonight. Number 2, the applicant did reduce the size of the building by approximately 20,000 square feet in footprint. Number 3, the loading docks were located away from the residential lots 14 and 15 at the request of the objector. And also, the applicant has redesigned and is in the process of redesigning its stormwater management system, which will divert a basin that was a particular concern also away from lots 14 and 15, another change instituted at the request of the objector. With me this evening, I do have 2 witnesses, but I will turn it to Mr. Bernstein, who I believe will address some legal issues for the board.
Mr. Flynn, just for my edification, I apologize. What section of 188 are we discussing? 18874?
Correct.
Thank you. Just for the board's edification, there is a provision that allows for more than 1 principal building, subject to site plan approval, so let's deal with that. It's not an automatic, it requires it, but that's separate and apart. There are multiple issues here, starting with the standing issue. The documents that have been provided, and I'm not sure they were provided necessarily in a timely fashion because you unfortunately drew the short straw for being here tonight. Mr. Ogrodnik, however, was here the last time and was told that the board wanted every document in prior to June 26th because of the holiday and the need for Mr. Mayu, Mr. Coyce, and others to review. We wanted everything in by June 26th, and the only thing that showed up by June 26th was Mr. Tyner's engineering report and a partial stormwater report, and everything else happened after. But that's the minor item of the items. The condominium documentation, I don't believe at the moment necessarily answers the question that I, in fact, raised at the March 8th meeting regarding the issue of standing. The documents are incomplete. The documents are actually draft documents, and they literally are draft documents because there are names in the documents of people who have absolutely nothing whatsoever to do with the application. The other issue, frankly, is it's a question as to whether this is really a condominium situation or not. There are phrases and issues raised, and I think Mr. Torriello also has his own comments that would seem to indicate this is not really condominium, it's just another way of calling it a subdivision without calling it a subdivision. And that has been and continues to be, as to that issue, one of the major issues on standing. The fact that the current property owner has given permission to allow your client to put this application before it doesn't necessarily give it standing. It gives it a right to be here with his permission. The question really is, who's the owner of the property? And right now, the owner of the property is still the individual who has granted permission, but still the owner. I think Mr. Torriello has some comments he wants to make on that issue before I get to my other issues.
Certainly. Yeah, I would in the most succinct fashion, suggest that the incomplete documents that were submitted certainly suggest to me that this is really an illegal subdivision. And I say that because on the draft deed, it indicates a conveyance of less than the full property, designating a certain amount of acreage to one owner, and it's unclear because there is no document submitted as to who the owner would be on the second portion, that's a subdivision. A condominium would have one ownership of the property, and that there could be individual ownerships of structures on there. The second problem that I have is this easement and maintenance agreement. The fact that there's an easement agreement also confirms that this is not a condominium association, because they're giving individual property rights, which in a condominium association, there would be common areas. And so that would be, everybody would have a proportional interest in that as an owner. So again, the record is clear that the submission from the applicant is not complete, but from what has been provided, there can be no conclusion, in my opinion, other than this is an attempt to do an end round by withdrawing their subdivision application and then utilizing a condominium association as a, I'm going to use the word scheme. I know that may sound charged, but it looks like a scheme to me to do a subdivision which they otherwise couldn't do because there's no frontage for the second lot, which is why they withdrew that. And that will lead me to comments.
May I briefly respond?
Yeah, I'm finished.
First of all, the applicant in its own prerogative decided to consider this arrangement and eliminate the lot not abutting a street, Section 35 variance. That's within the applicant's prerogative to do so. Now, I can't find anything under New Jersey law that prevents a two-unit condominium agreement between two condominium unit owners, operating in a commercial capacity. We are in the process of dealing with the documents with the landowner. Those were submitted in draft format to the board to just indicate that we are, in good faith pursuing those documents and to properly, sign them and record them pursuant to law. I mean, in no instance does a board, require, as prior to the application being approved, a full vetting of every single maintenance portion of a subject site. A lot of times, townhome complexes come in, and as a normal condition of approval, the HOA documents are supplied after approval to the satisfaction of the board professionals. That's what we would intend to do here. We provided them in draft format to indicate that this is what we're considering. We're allowed to do it under law, and any objection that they have to those documents can certainly be worked out as condition of approval. And the reason that the applicant here tonight does in fact have standing is because the definition for developer under the MLUL, which confers standing on an applicant, is that they can be a contract purchaser. It just so happens to be that rather than be a contract purchaser for a subdivided lot, they will be a contract purchaser with the authorization of the property owner for a condominium unit to be executed on the property. So to me, it's a distinction without a difference, and to parse out the specificities of the documents that we provided regarding this condominium idea should not, I think, preclude the board from hearing the application tonight. They're in draft form, and they will be cleaned up in due course throughout this process. What we tried to do is provide the board with a general overview of what we want to do with the site. And again, I cannot, and Mr. Bernstein can point to one, then maybe I'll stand corrected, but I cannot find a provision under New Jersey law that prevents a two-unit commercial condominium association. That's all we're trying to do. It's sufficient to confer the applicant's standing. We provided the notarized affidavit like the board requested from the property owner.
If I could just briefly respond. I would refer the board to section 46:8B3 I under the definitions, and I would also just refer to common law, and council said he has the right to subdivide a condominium where there's individual land ownership in a condominium. I've never seen that in my 33 years of practice in law. I can't prove a negative. If council says that that is consistent with the definition of 46:8B3I, he has the burden to show that. I think the statute speaks for itself, and I think that when you're dealing with a condominium association, there is one owner of the land, one. You don't carve out 5 acres of a 17-acre. That is a subdivision. Whatever council says, you can't spin that any other way, because the reality is, in the application, they're subdividing the land. They are giving 2 separate independent ownerships of property in addition to the building. That is completely inconsistent with what a condominium and a condominium association is.
The definition that you were citing, what is that for?
The definition of condominium property.
And it clearly states in there,
Condominium property means the land conveyed by the master deed, whether or not contiguous and all improvements thereon, all owned either in fee simple or under a lease. They're having separate ownerships, singular.
Counselor, you want
It's NJSA.
46:8B-3, subparagraph I.
Yeah, I would just disagree with the characterization. I mean, again, the
Well, not the characterization, but what's the what is the legal definition of a
Well, no, I mean, if
condominium?
he's reading from the statute, but the point is that, you know, if the documents are in draft format, they can certainly be cleaned up in a way that sufficiently represents what's required under New Jersey law. I wouldn't say that we're trying to end run anything.
So what you're suggesting is you're going to clean those up to create a single ownership?
Yes.
That it's equal, that...
I believe that's the intention of my client, yes, as he's nodding in the background.
I know, well, we may need to get him to testify at that point. But Mr. Bernstein...
We're at legal issues here,
Right.
whether Mr. Remington wishes to nod or testify or not. The documents before the board are what they are. They make it cleaned up down the line, but there are issues as to whether or not this will actually, counsel for the applicant continues to show you that he has a sworn affidavit from a property owner who is not the applicant that this can go forward, but there's no indication that I'm aware of that either Mr. Remington is being retained by the property owner to build a building on behalf of the property owner. And the reason why the applicant withdrew the other variance was issues raised by the board's professionals and the board as to whether or not they could comply with the subdivision rules regarding what ostensibly is a flag lot. That's part one of the issues. Part two of the issues relates to whether or not this is in fact a new application.
Kim, before we move in there, I just want to ask Counselor here is, why was it drafted that way where it didn't appear to give equal ownership?
I can't answer that. I didn't draft the documents.
But you said your client, that was their intent, so I'm trying to understand.
Well, the intent is to create a
why they would accept a
condominium.
draft that doesn't convey equal ownership in common land.
Well, I would say
Seems pretty simple.
Well, I would say they didn't accept the draft. That's why it's a draft.
No, they
If
did accept
If
it.
they
I
had
mean,
accepted it, they would have signed it. I would say as of,
And they would have submitted to this board for our review and consideration?
again, it was submitted in draft format just to show where we are in the process.
It was submitted to the board, and Mr. Flynn can disagree with my characterization, to show you the new process to somehow get around the issue that this is not really a subdivision when in fact it quite possibly could be. I'm not saying it is.
Right.
I'm not saying it isn't. It's one of the many issues over the last 48 to 72 hours that I have now had to deal with relates to that. There is an issue that Mr. Torriello raised in his letter of Tuesday, because the man feels the need to give me more presents than I need already, which raises the issue, which I have also, I'm going to be upfront. I have not come to a conclusion on any of this. I am trying to find my way through all of these items, and I'm going to have a suggestion, which I suspect nobody is going to like when this is all over. But Mr. Torriello has raised the new application issue, and I think to the extent he wants to raise it before the board for purposes of board consideration, he should, and I'm sure Mr. Flynn, whose office has had this letter since Tuesday, and I believe Mr. Ogrodnik opined somewhat from wherever he is yesterday that has been provided both, so that everybody's aware, both letters have been provided to the board so that everybody, the board has Mr. Ogrodnik's letter, the board has Mr. Ogrodnik's email, and the board has Mr. Torriello's letter. So I would suggest that Mr. Torriello's turn on this one, he go first, then Mr. Flynn, and then we'll go from there.
Briefly, again, as council indicated, you all have a copy of the letter, so it's not my intent to reread it. You have it, but this application has been extremely frustrating for me because we've been at this over a year, and every time we come here, there's a change, there's something different. And you know, outside agencies don't have a single piece of paper of what's going on here. The board professionals, every time they're looking at a document, it's something different. We started out with a subdivision. Now there's no subdivision. Tonight, there's another dramatic change there's a first-time reference of a contract purchaser. We don't have a contract of a sale of land. Every time, these are significant. They're not insignificant changes. And it's one thing if you're doing a minor tweak, but you're talking about going from a subdivision to no subdivision, changing grading, changing locations, changing size, changing everything in this is
I'm just going to interrupt you
significant.
on those points because Counselor here clearly stated they made changes based on what you had requested, so I don't think that would be fair points at this point, if that was something that you had requested, those
Okay,
changes. So let's,
we did not request the change in the subdivision, okay? That was an issue that was raised by the board and the board professionals that they did because they had to address a significant legal issue. And that singular change in and of itself, I believe under the case law that I provided, represents a significant change
and what was
without more.
specific about that case law? Did they actually talk about that someone had a subdivision and took it away?
No,
So
no.
then what's the direct
They
correlation?
talk about, the case law that I provided is to give the board guidance that if there is an insignificant change, the board should not consider those changes as a new application. If the changes are deemed by this board to be significant, then under the case law I have provided, it gives the board the right to say, we deem this a new application. The case law I provided had to do with zoning res judicata cases, 3 Supreme Court cases, which specifically address the issue of whether a change is substantial or not substantial. And the Supreme Court says, for the board to use as a guideline, if there's a change in the application of 10%, so it's 90% identical, if there's a 10% change, the board can consider that as a substantial change.
And did the courts-
And if it's 20%, then the Supreme Court says the board should consider that a substantial change.
How do you measure the percentage change?
That's up to the board. That's up to the board.
I thought you said the courts
and it-
provided guidance.
The courts-
What's my unit of measure so I can determine whether it's 10 or 20% change?
Well, that's up to the board. That's up to the board on each individual application. But there's at least, it's not just.
Well, then I'm going to say the burden of proof's on you. Can you please define what you feel is 10 or 20% change?
I believe
But
going.
with specifics, what changed by 10%, and give me that measure to show me.
I think withdrawing a subdivision, that, to me, that's a significant change.
And was
I
any of
want
those
to
three court
comment
cases
on.
involved
I'm
a
sorry.
subdivision change?
Okay, I'm sorry.
Any of your cited cases involved a subdivision change? I'm just looking for apples to apples here to help guide the board here.
Yeah, I think that the Supreme Court's opinion, it was designed to guide the board in your deliberations as to how you would determine whether or not a change is substantial or not. I believe it is. Ultimately, it's up to the board to determine whether you agree with the position or not. But I believe that the changes that have gone on for the last year are substantial.
So-
And I
Can
want,
I
I
briefly
also
respond?
want to comment on Mr. Ogrodnik's letter, which suggested that all of these changes were made at my client's request, which is incorrect. My client has sought to have a conversation with Mr. Reddington since last August, almost a year, and he has been ignored for an entire year. And just like the condominium documents, and just like most of the submissions that come at the 11th hour, there was a discussion with my client in the last week, okay? And yes, does this represent some movement towards some of my client's concerns? Yes, it does. Does it represent from day one the concerns that my client had? No. But your expert addressed my client's concerns since the beginning in the report. It's item, I just want to go to your engineer report. If I could give me 1 second, the board's engineer report at item, I believe it's item 17. It's item 17 on page 12. The applicant shall submit groundwater mounding analysis for biodetention basin. That concern my client raised a year ago and was completely ignored and is still ignored, which is why your professional raised it, because they haven't addressed it. So
Right, but
for my
I
adversary to suggest that my argument is disingenuous when the
But we're talking...
the interaction between the parties has not been in good faith from the applicant's standpoint. I want the record to be clear on that.
And that's fine, but you're trying to address or trying to convince the board here that there is a significant change. So if they haven't addressed that, then there's been no change in that, I'm assuming, if that part of the site plan hasn't changed. So I want just to focus on what has changed. And again, Counselor of the applicant, cited a couple of examples of changes that he said that.
Yeah, we're also
that you
talking
had
about a
inquired.
condo association for the first time. I think that's a significant change. This is ongoing change.
Right,
Nothing is constant.
But we
on
need to
this.
define what change is, and we haven't gotten to that.
Yes, you do. I agree.
And I don't
I
know
agree.
what, how to quantify that as a change, going from a subdivision to a condominium proposal.
And all I would say to that is, I guess, to defer to your legal counsel on that. I'm providing the guidance that we have from our Supreme Court, and I've expressed my opinion on the matter, but ultimately, it's up to you to deliberate and decide, to work through that issue.
Mr. Chairman, if I could respond. Council's correct that it is within this board's prerogative to determine what is considered a substantial change. Now, I had the opportunity to review in depth the case law that he cited in his letter to the board, and I'll briefly go through it. The seminal case, Lakeshore Estates versus Denville Township, that's 255 New Jersey Super 580, Appellate Division 1991. In that case, the applicant added 28 acres of developable land to the proposal, okay? The other cases that are cited, notably Bressman and Russell in his letter, he says that if the application changes by 10% or 20%, that might be substantial enough for the board to consider it a new application. The reason that's incorrect in this circumstance is in those cases, the applicants were specifically requesting C1 hardship variances. The applicants went before the board, they had a building that exceeded the setback requirement or exceeded impervious coverage. The board denied them, and they came back, and the board was considering whether or not the application was substantially different enough so that the board could hear it, because you can't just keep having the same bites at the apple. And in those cases, the applicant shrunk the proposal, therefore changing the level of hardship and allowing the board to reconsider the C1 bulk variances. There's no standard enunciated by the Supreme Court about what a 10% or 20% change to an application is. Here, we've added no additional area to the proposal. It's the same lot, it's the same site. There's no new variances. If anything, the improvements are less intensive. And I'm not suggesting that my colleague's argument is disingenuous. I raised 4 points that were changes that this applicant made to its application. One of them is the condo association, as we've already discussed. One of them is shrinking the building because, as we know, we don't want a use that's too intense for the site, and we made a 20,000 square foot reduction. I wouldn't say that's substantial. It's a modest reduction, seemingly.
More than 10%, though.
Right, but we're not requesting it as part of hardship relief. It's a request to say, when we apply for our C2 bulk variances, that it means that it's a better planning alternative. The other two issues, notably the placement of the loading docks and the style of the drainage improvements, were changed at the request of the objector, and to the extent to which they want to assert that that plays into a substantial change in our application, they should be stopped from doing so, because we've done that in an attempt to try and mitigate the impacts to surrounding sites, including his clients. And again, if you look at the case law, there's a difference between coming back to the board after a denial and having the board reconsider a proposal that's considerably smaller in scope when you're analyzing the hardship compared to what we're requesting here. And the final thing I'll say is there is a case, if I'm pronouncing the plaintiff's name correctly, Schmidhausler versus Planning Board. That's 408 NJ Super 1, Appellate Division 2009. They said when the board considers whether or not an application is undergone a substantial change, the quote central focus, the board should consider whether the central focus of the application has changed. Obviously, that's not what happened here. We're proposing essentially the same building. We've modified some improvements to lessen off-site impacts, and we'd ask the board again to consider us to have standing and proceed as we feel we're entitled to.
Mr. Bernstein.
And now you know where I am. I feel like Mr. Berlin in his comments of earlier.
I don't want to make your life harder, Mr. Bernstein. I'm sorry.
There are two options that I see available at the moment. And as I think I prefaced it a few minutes ago, Mr. Chairman, nobody's going to like either one of them. Option one is a short-term fix that I'm not so sure necessarily actually is a fix. Applicant wants to go forward with his application as proposed tonight, with the understanding that the only item that really can be discussed before this board is Mr. Tyner's submission on the 26th. Anything else is out of time. And while I understand the infamous 10-day rule, we asked for longer time well in advance because there were rumors, there were holidays, and possible vacation and related items and getting people. And as the board is aware, Mr. Mayhew's report and Mr. Coyce's report showed up this afternoon. That, however, would require both Mr. Flynn and Mr. Torriello and their clients to agree on the record. Were they writing in my office by 4 o'clock tomorrow that they agree not to raise a jurisdictional or other standing issue, depending upon whether or not the application was approved or denied, claiming that since the board allowed the application to go forward, the board can no longer address the standing issue. And the standing issue relates to the condominium and related items. The second alternative, which I would indicate is more conducive, but will be guaranteed to hear at least possibly one audible gasp, is to give both parties an opportunity to submit to me, if they wish, additional argument. I realize that Mr. Flynn is at a disadvantage. He is filling in tonight. Mr. Ogrodnik's response was on the fly from wherever he is, and that if anyone wants to update their arguments or give me additional case law to consider, to give them a time to do so with a time for me to respond well in advance of another hearing date. That would, however, require the applicant to now, we have a very strange situation on top of all this. The TOD for this application is 7/28. However, the applicant has asked for and been given an October 5th hearing date, which sort of becomes an oxymoron, because if we don't get an extension on the TOD, then the October 5th hearing no longer has any validity to it, and the board would have to render a decision on all of this tonight as is, which I'm assuming the parties don't really want to happen, though if they make the board do it, we'll pepper the record accordingly. So the alternative would be to set a date, probably by early August, for everybody to submit what they want, and for me by the end of August to submit my recommendation to the board. And I underline the word recommendation. Contrary to public belief, I do not make board decisions, because if I did, you would all be home by now. And depending upon what happens, we either go forward or we don't. I am loath to recommend the first one, because it is fraught with legal problems when a judge says to me, well, if the board didn't think they had a jurisdictional issue here, why did they let the application go forward? And I have heard too many people in black robes state the semi-obvious, well, Your Honor, the parties all agreed. Well, but the fact of the matter is you let the thing go forward anyway, and the only one who gets embarrassed is moi. So I am suggesting the second, which is to give Mr. Flynn or Mr. Ogrodnik or his office and Mr. Torriello a drop-dead date to comment, and if they want responses, we can talk about that as well, for a drop-dead date to submit anything they want for me to consider to advise the board, ostensibly on the standing issue and the application issue, as it also relates to the condominium issue, because frankly, showing me a draft document that is edited with other people's names in it doesn't give me a lot of warm, and for those of you warm and fuzzy doctrine people, a warm and fuzzy. I'm assuming this was an attempt to try to get something on the record. Maybe Mr. Flynn's office can clean up whatever they plan on cleaning up and address the issue. Maybe that will resolve itself, at least as it relates to the property issue. Whether it's standing issue may or may not still be resolved. That's my suggestion. It's up to Mr. Flynn and his client. It's up to Mr. Torriello and his client what they want to do. My suggestion is maybe they take a few minutes to have conversations with their respective clients and come back in 10 or 15 minutes and tell us what they would like to do. And if they're interested in the offer, we can set the dates.
All right, I don't know if we want to just have any board members opine at this point?
It's up to the board
Because I may
members.
provide guidance,
Well,
which way the board may be thinking, if in any direction, but
I think that, quite honestly, I think it would be best to have a break so that they could talk amongst themselves, and possibly we could talk amongst ourselves with our attorney and see when we come back what we're feeling. But I think the first step that has to be decided is, as Mr. Bernstein has said, is the standing issue, and the fact that we don't want to be put into a catch-22 situation.
yeah, no, and I concur with that, because Mr. Bernstein has had experience in being embarrassed. Nothing taken again, but
stating that on the record, Mr. Chairman.
we've known each other 20 years, so I think
Has had a number of opportunities to be embarrassed.
but it's a very valid point. So, all right,
I'm just telling them it was your idea, so just be aware.
all good. It's not like I haven't been called into court myself either, so.
I know. I mean,
All
that's
right.
my suggestion, Mr. Chairman.
Let's take-
Parties take about 10 to 15 minutes.
Let's take a good solid 15 minutes. I can't, my eyes are horrible. 5 to 8, 5 to 9. We'll reconvene at 5 to 9 according to that clock. Okay, we're back in session. Mr. Bernstein, I'm going to let you lead this.
Gentlemen, any responses to the suggestion?
We're willing to accept your preferred course of action to engage in briefing on the issue. Council and I have decided that 14 days would be enough time for us.
I was going to give you more.
The only thing is, I actually, as a response, was hoping that we could get assent from you, Mr. Bernstein, that if we, have 2 weeks, that we can move your end of August suggested deadline for a decision in a little bit, mainly because my client, as the board may be aware, is going to, continue designing the project, and obviously if something substantial comes in that, very seriously affects my client's ability to prosecute this application, we don't want our work in the field to be for naught. So we were hoping maybe to get this issue resolved.
Well, you agreeable, Mr. Torriello, to 2
Yeah,
weeks?
council said that they were concerned about continuing incurring costs on an application.
Microphone.
Oh,
Though
I'm sorry.
you are louder
Yeah, the
than
short answer is yes. The concern was expressed to me, and I agreed to the accommodation.
Then here is the proposal from a date point of view. All briefs to me by close of business Friday, July 28th, which is 2 weeks from tomorrow. If either or both of you would like to submit a rebuttal, I need to know that by 3 o'clock Monday, July 31st. And you will then have to the following Monday, which is August the 7th, to get them in. My office will have a turnaround, as I start to figure out who I'm going to. Yeah. It's all around my vacation, so I remember those things. After that, we start to lose dates. If everything is due in by the 7th, my office will have a decision by close of business the 28th, which is Monday, August 28th, which will give you more than sufficient time. I assume you both, or somebody, Mike will be back.
I would assume so. I mean, that's, again, we would just respectfully request that if, our briefing's done by the 2nd, that.
The 7th.
I thought you said the 2nd.
7th.
7th?
You the 2nd, me the 7th.
No, both of you the 7th. How about,
Let's go over that one more time.
original briefs due July 28th, 5 PM. You want, wasn't like shooting in here. If you want a reply brief, you need to let me know by 5 o'clock on July 31st, and that will be due by 5 o'clock August 7th. I will have my thing due by close of business August 25th, which is 18 days from when you all get it in. I think that's relatively.
Yeah.
Any issue?
If that's acceptable to the board, we can go along with that, sure.
Which then requires one more thing. Extension on the time of decision from your client.
So we're returnable here,
October the 5th.
okay.
And we all know, and I'm going to quote the chairman from slightly earlier this evening, we are not going to finish the application if we go forward with it in one night.
I mean, I think we
So-
could do the same thing, end of the year, like we did with the last application, I think would be sufficient.
That makes life much easier, thank you. All right, Mr. Chairman, we have set forth the briefing schedule. If I remember again what it is, I will send you both an email.
I have it in my notes if you'd like me to email it.
I will send it if I'm wrong. I'm sure I'll hear from either or both of you tomorrow. With supplemental briefs relative to the standing issue and the substantial change issue. That's it, folks. I don't want to hear about, because all the report, by the way, are all the reports in, Matt?
Are all of the, everything that's
Relative to this application?
is in Civic Clerk now. I know that there was a 10-day issue with some of them, but my understanding is everything's there.
I think there's some issues that may be raised by the engineer and/or the planner in their report, that if you want to supplement with
10 days in
additional
advance of
reports,
October.
at least 10 days in advance, and more the merrier, because it then gives everybody a chance to respond.
Understood.
But no less than 10 days. An extension, this matter to be continued until Thursday, October the 5th, 2023, at 7 PM or soon thereafter, as the matter may be heard, with a time of decision extended till 12/31/2023.
Okay. So with that, May I have a motion to approve?
Mr. Scobell, you want to make
the
So
extension?
moved.
Second.
Okay, any final comments from the dais? Hearing none, roll call, please.
Mr. Peason?
Yes.
Mr. Radowitz?
Yes.
Ms. Smith?
Yes.
Mayor Lapani?
Yes.
Vice Chair Julian?
Yes.
Chair Sirachi?
Yes. So,
Thank you, gentlemen.
so with that, just want to remind everyone, we do have a special meeting next Thursday at 7 p.m. And then also, we do have a schedule on the business meeting, or we don't have anything scheduled for the business meeting, do we? So I would entertain a motion to cancel the July 27th business meeting.
So moved.
Second.
Okay, do we need,
Second.
can we do that by affirmation?
All in favor?
All in favor? Aye.
Which one of you I dare is opposed?
Okay, with that, I will I will entertain a motion of adjournment.
So moved.
Second.
All in favor? Aye. Okay, good night, everyone. See you next week.